Falsehoods observes, the phenomenon of fake news is nothing new. Since time immemorial, a battle for hearts and minds has taken place between people who host different views and seek to persuade others of their beliefs and causes. Between politicians at the hustings, between companies through elaborate public relations exercises and spin, and between countries, most vividly played out during the Cold War between the US and the former Soviet Union, each forwarding the superiority of the capitalist and communist systems respectively. What we refer to as fake news today, with misinformation and disinformation at its core, has been the domain of propaganda in the days before the internet. As framed by Claire Waddell in her submission to the Select Committee, at one end of the spectrum, misinformation has been a method of choice of individuals, politicians, companies and countries. Here, misleading content, false context, imposter content dominate. At the other end is aggressive disinformation with falsified or manipulated content which seek to deceive an audience or a reader. This is usually the domain of sophisticated state and well-endowed non-state actors. The advent of the internet and more recently social media, where communication has been democratized with both positive and negative repercussions, has brought the ease of propagating fake news center stage. The political economy of social media companies and their algorithms, which are skewed at extracting profits, in some cases regardless of the consequences, accentuate the problem. Bots and the existence of enterprises that charge for services to manipulate the public discourse, subvert democracy and elections, and weaponize information have become a feature of the online world, with many examples highlighted to the Select Committee. Over the last few years, Western powers have identified Russia's employment of hybrid warfare, combining both a hostile information campaign employing both misinformation and disinformation before and during the onset of hostilities as a norm for future conflicts. However, it would be a mistake to suggest only Russian involvement. The arc of history has proved that many countries, even those friendly to Singapore, are no less seasoned at subversion and subverting even democratic forces in other countries. And it would be naive to assume that the employment of misinformation and disinformation is not a permanent aspect of the world we live in today, much of which is lived online. Clearly, there is a problem at hand. The question is, how should Singapore deal with the problem? The government has proposed the Protection Against Falsehoods Online and Manipulation Bill before the House today, what I will henceforth refer to as POFMA. After spending a long time deliberating the nature of the problem, including forming a Select Committee of Parliament, the government decided not to consult the public on how it preferred to tackle the problem. To this end, a lot of the public apprehension over the bill can be located in its choice of decision-making authority on matters concerning online falsehoods, the executive. The remedies available under the bill are virtually identical to those individuals and companies can rely on under the Protection from Harassment Act, or POHA. In deciding that the executive will determine what an actionable falsehood and what is not, there has been significant disquiet even amongst moderate and politically disengaged members of the public about the potentially wide remit of powers extended to ministers through this bill. So the public routinely get involved in political discussions both online and offline on the effectiveness or ineffectiveness of policies, the appropriateness of executive action, the lack of information on matters of public interest, such as the size of our reserves, amongst many others. By their very nature, such discussions are also limited and even exaggerated sometimes because of a lack of disclosure by the government or the absence of any freedom of information regime to equalize the asymmetry of information between I'll say that again, to equalize the asymmetry between the information and facts available to the executive as compared to the general public. Given our unique laws that govern how the press operates in Singapore, the infamously local phrase out-of-bound markers, and our unique political culture steeped in a history of hauling up members of the public and politicians who uttered defamatory statements to court to be slapped with punitive damages, there is a genuine sense amongst the public that this bill can be easily abused in the wrong hands. It does not help that the public do not appear to be clear on what can be said and what cannot be said. For example, how does a false statement of fact interplay with an opinion or comment? I believe the Minister also recognizes this point in comments to the Straits Times last Saturday about whether the bill could have the unintended effect of self-censorship. The Minister said, and I quote, "We need to educate the public that the bill applies only to people putting out falsehoods and that various ministries like the Education Ministry is working on public education in this area," unquote. Mr. Speaker, the Workers' Party opposes this bill. All the Workers' Party MPs will speak against it, and our objections centre primarily around a fundamental matter. First, we do not agree that the executive should be the initial decision maker on matters surrounding false statements of fact. Secondly, we do not support the uncertainty over the circumstances under which the executive can move on matters that rest purely on a minister's subjective opinion that a false or misleading statement is nonetheless not in the public interest, for which a correction or takedown order, amongst other directions, are necessary. While the government must legitimately be able to apply to shut down malicious actors, a court order should legitimize this action that needs to be undertaken. In fact, the Select Committee report noted representatives raising the prospects of the executive itself spreading falsehoods. This should give all Singaporeans reason to pause and consider whether the bill that will be passed with the executive as the decision maker is truly in the best interest of Singapore. In fact, it is my case that POFMA can easily become a proverbial Damocles sword that would hang over members of the public who do not support the government's narrative or toe the government line. So it would be useful for the House to revisit Recommendation 12 of the Select Committee report and the analysis that precedes it. Here, the committee's report deliberated on which entity should become the decision maker in determining what is a falsehood. In fact, the Select Committee outlined three other alternatives. First was the courts. The second was the establishment of an independent body or ombudsman that would issue directions. And thirdly, the report considered the prospects of social media companies themselves acting upon notification of falsehoods by users with a recourse to the courts. At paragraph 364 of the Select Committee report, the committee acknowledged the views of some representatives, including those who were skeptical of the executive as the decision maker. Ironically, much of the concern that has been expressed in the public realm since the first reading of the bill was actually foreseen by the Select Committee report. At para 364b3, it read, and I quote, "Representatives raised concerns about whether executive action would be credible. There was concern that executive action could feed fears over the abuse of power. It was also pointed out that executive directions would not be able to deal with falsehoods spread by the executive. In contrast, the proposal to have the courts as the decision maker did not elicit any significant apprehensions. To reinforce this point, it is apparent that the bill gives remarkable leeway to the executive to define what a falsehood is, especially since the government has said that it will not act on all falsehoods. In fact, Clause 2.2 legislates that a statement can be deemed by the government to be false if it is misleading, whether wholly or in part, and whether on its own or in the context in which it appears. In the public understanding, this clause gives broad latitude to the executive to clamp down on what it deems to be even misleading statements, which may not be false per se. In fact, it is fathomable that some statements the executive may interpret as offending are likely to exist along the misinformation and disinformation spectrum eloquently laid out by Claire Waddle in a submission to the Select Committee. Some statements would exist in the middle of the spectrum where reasonable people would disagree about whether such an offending statement is indeed prima facie false or misleading and against the public interest. In addition to Clause 2, Clause 10 legislates that any minister can issue a whole range of directions if that minister is of the opinion that it would be in the public interest to issue it. Clause 4 lists 6 broad considerations of what would be in the public interest. Reference is also made to a diminution of public confidence in the government, a term I would argue can turn on how thin-skinned or thick-skinned the government of the day is, be it today or in the future. For example, some weeks ago, some critics of what many reasonable people would consider, correctly or incorrectly, to be a pro-government influencer, Nas Daily, were accused of seeking to undermine confidence in public institutions. These critics alleged double standards on the part of the executive in allowing the applicant, a foreigner, to mark his presence in Singapore because of a different interpretation of what the executive would deem to be a cause-based event. This led the Singapore Police Force to release a statement which framed the allegations of the critics as, I quote, "a malicious attempt to undermine confidence in public institutions," unquote. So if this example, rooted in a different perspective of how the Public Order Act is applied, outlines the contours of what the threshold of undermining public confidence as defined in the bill is, then the irresistible conclusion must be that the public interest limb detailed in Clause 10 can potentially be very easily invoked by the executive. Such a conclusion would explain why even moderate Singaporeans have raised concerns about the prospect of POFMA having a chilling effect on the public discourse at the hands of a very easily triggered executive. Now, if an exceedingly low threshold to trigger Part 3 was not enough, the explanatory statement of the bill at page 69 clarifies that the 6 scenarios of what would qualify as the public interest are actually only the tip of the iceberg. I quote the explanatory statement. Clause 4 gives a non-exhaustive, and let me stress this again, a non-exhaustive definition of the expression in the public interest, which is part of the condition for making the various directions under this bill, unquote. So in fact, what this bill is really saying is that Clause 4 is merely a precursor to another potentially unknown list of definitions of what could be in the public interest. Mr. Speaker, we have had episodes in our history where decisions made by the executive, by the virtue of powers legally exercised, were questioned with skepticism by members of the public, including even members of the executive years after the event. Operation Spectrum, or the Marxist conspiracy of 1988, is a good example. It is public knowledge that a senior cabinet member left the cabinet after expressing doubts about the executive's exercise of powers under the Internal Security Act. Senior Minister Tharman Shanmugaratnam was also quoted by the media as being doubtful about whether the individuals arrested in 1988 were communists. These are not the opinions of lay members of the public who have access to all the relevant information and individuals involved to make a decision or clarify their understanding of events. It would appear that reasonable people, even within the executive, would opine very differently on some matters. But yet each minister can invoke powers under this bill, even if a fellow minister may not be in agreement. To avoid such inconsistency, wouldn't the courts represent a more neutral, transparent, accountable, and uncontroversial platform to rule on such matters? The government has argued that under the proposed bill, the courts are the final arbiter of truth and that an uncomplicated appeals process to the courts would address the concerns of aggrieved parties. Even so, sir, the judicial culture in Singapore is highly non-interventionist. The courts cannot overrule executive directions lawfully undertaken pursuant to legislative powers passed by this House. False statements, which can include misleading ones, nonetheless require the independence and neutrality of a reasonable man who, in this case, will not be a judge in the first instance, but a PAP minister. It is open to question whether a traditionally non-interventionist judiciary will challenge what the executive deems to be reasonable under the bill, particularly in the face of broad definitions like misleading statements and the public interest. Furthermore, an appeal to the High Court for a Part 3 direction under Clause 17 does not give leeway to the court to order what is just and equitable in the circumstances, powers which a genuinely neutral appellate authority must ordinarily host. Instead, POFMA limits the grounds for appeal to the courts to 3 circumstances as listed in Clause 17. While judicial review nonetheless applies, it is a high bar as judicial review does not cover the merits of the minister's decision but only its legality. More fundamentally, the executive will have to carefully assess and determine what constitutes a statement of fact, something which is not necessarily a straightforward exercise. What is not stated in unequivocal terms by the government is that the line between satire, opinion or comment and what the executive may deem to be a false or misleading statement of fact in the public interpretation can be highly subjective. This point was raised in the Court of Appeal judgment in Review Publishing versus Lee Hsien Loong, quoting Evans on defamation, albeit in the context of the defense of fair comment, where it was said, and I quote, "It will often be very difficult to decide whether a given statement expresses a comment or an opinion, or by contrast constitutes an allegation of fact. The same words published in one context may be statements of fact, yet in another may be comments. Therefore, whether this element of the defense is established as one of fact is dependent on the nature of the imputation conveyed and the context and circumstances in which it is published. The test in deciding whether the words are fact or comment is an objective one, namely whether an ordinary reasonable reader on reading the whole article would understand the words as comments or as statements of fact. However, in acknowledging that deciding between an opinion or comment and a fact can be a difficult exercise, to say nothing of misleading statements, it would follow that the application of a nonetheless objective test in some cases may likewise not be a straightforward exercise, especially in cases of misleading statements where politically charged decisions need to be made. Mr. Speaker, it would appear that a key factor in the government's selection of the executive as opposed to the courts as the decision maker on matters concerning falsehoods and manipulation turn on how quickly a false statement of fact can be corrected, removed, and generally dealt with speedily. If so, it would be important to put this factor into perspective and consider alternatives that seek to balance the urgency of moving against an online falsehood and having a decision maker that is more acceptable than an unchecked executive. Firstly, under civil law, quick remedies are available where service and the presence of a respondent in court can be dispensed with. And to this end, the ex parte process is not an unusual judicial remedy to deal with certain time-sensitive applications. But one need not reinvent the wheel here. The prospect of interim orders made in favor of the government in the face of a prima facie falsehood, just like how an individual or company would apply under POHA, can possibly also operate to deal with online falsehoods and manipulation quickly and effectively. To this end, Part 3 and 4 of the bill have close similarities with the remedies for online falsehoods this House passed earlier under Part 3 of POHA. The new Section 15 and 16 of POHA envisages identical remedies such as stop publication and correction orders that can be invoked by companies and individuals in Singapore, in addition to orders sought against tech companies upon application to the harassment courts. Mr. Speaker, if ordinary Singaporeans and corporates registered here are expected to apply to the courts to deal with online falsehoods and misleading statements made against them, it would be sensible for the executive to surrender itself to such a process as well, particularly since the meaning of a falsehood is identical under both POHA and the bill. The harassment courts dealing with all online falsehood applications from individuals and companies and the government would also result in a consistent application of the law in matters involving online falsehoods and misleading information, resulting in not only greater clarity for all parties, but would help in public education on permissible and impermissible forms of expression. In cases of sensitive matters involving national security, in-camera applications can be made by the executive to the harassment courts. To this end, I believe there is scope to introduce processes involving duty judges to deal with an urgent application from the government speedily or at very short notice. Likewise, there can be times where there is heightened risk of false or misleading postings online. This can happen during elections, for example. In such a scenario, urgent interim orders can be ordered by duty judges available at short notices to quickly deal with false content that threatens to subvert the election process. The difference in time taken between an executive direction and an expedited order through the judicial process in such cases may not be significant. Here, I think it's helpful for me to bring back the clarification from Senior Minister of State Edwin Tong that in the case of an online falsehood that threatens to go viral in 4 to 5 hours, if I heard SMS correctly, the answer was the courts can try to deal with that situation. Now that suggests that there is some room for the courts to deal with issues speedily. And on the other hand, an aggrieved party is also free to apply to the courts to challenge, vary, suspend or cancel a court's decision. In conclusion, Mr. Speaker, the Workers' Party is of the view that as a matter of principle, the courts should be the decision makers at the very first instance on matters that pertain to deliberate online falsehoods and manipulation. The fact that the bill would have to regulate what some reasonable people may well interpret as an expression of free speech under Article 14 of our Constitution must give us reason to pause and question whether the courts are better placed to exercise judgment on this point. The fake news domain is already a very controversial one. Some players are sophisticated, others will fake innocence when rightly called out. Some misleading statements will be completely political in nature, aimed at lowering the esteem and political prospect of election candidates, and there would be conceivably a whole litany of other scenarios and circumstances to consider. On its part, the executive will act in some cases of falsehoods, and in other cases it will not. In both scenarios, questions will be asked why the executive acted as such. Suspicions will be raised and perceptions could be formed. Politicization would be inevitable. But it is precisely because of these very reasons that the decision maker must be perceived to be free of conflict in deciding on matters concerning online falsehoods and manipulation as defined by the bill. Thank you.
Ms. Irene Quay. Senior Minister Edwin Tong.
Yes, Mr. Speaker. I have a clarification on Mr. Singh. He quoted me earlier in my speech in the POHA debate. Would Mr. Singh accept that while I said that the courts can try, I went on to say that it would be very difficult, and I went on to explain also that in the context of these kind of cases, it would be extremely difficult for a court to have a proper marshalling of the details and the facts and to decide on the case. I went on to explain all of that.
Mr. Speaker, I can confirm that there was an additional explanation to that initial comment that I beg your pardon, sorry?
In the terms that I've just set out.
Yes. The point I think that needs to be made here with regard to the use of the courts is that with an expedited procedure, which the Minister also confirmed under POHA, simple claims form, there is room, in my belief, that the courts can still represent decision-making authority which can act speedily.
The point that Mr. Singh is trying to put across is that the courts can do so in a matter of, and I think to say in your words, 5 to 6 hours. And I had explained earlier that whilst the courts can try, it will be very difficult to do so, especially having regard to the fact that they would have to assess the merits of the matter, and it's not possible to bring the case within that period of time.
Mr. Pritam Singh.
Mr. Speaker, I can accept the Minister's position on that, but philosophically I have a different view as to who the appropriate decision maker is, and it is my belief that we should try and see how the courts can deal with these falsehoods as quickly as possible.
That may be
Mr.
Mr. Singh's philosophical position, but he was trying to quote my speech to make that point, and I don't think that's accurate.
Okay, we note the positions taken. Mr. Villain.
Mr. Speaker, the Workers' Party is not denying the problem of misinformation, nor that there is a real risk of the public being misled, especially in the digital age. The concerns range from the creation of bots to spread disinformation, profiting from knowingly spreading falsehoods, and possible interference in elections by external state-sponsored actors. That said, the bill before the House to tackle online falsehoods has generated alarm and strong concern. My party colleagues before me argued some of the key objections of the Workers' Party that compel us to reject the bill. One such key objection is that the bill entrusts the job of gatekeeping truth to ministers and their alternate authorities who are part of the executive government and would be making certain decisions as interested persons rather than neutral arbiters. During a constituency event over the weekend, some residents expressed to me that when POFMA is passed, they would likely be very, very careful about what they post online and about private messages they send through their phones. Thus, when I saw the Straits Times opinion piece of Edwin Tong on 6th of May, I was struck by the headline which read that only a small group was crying wolf. I know that his intention in writing that piece was specifically to respond to the Asia Internet Coalition. But as he himself explained yesterday, the bill before the House is platform neutral and will apply to communications on closed platforms such as messaging groups. Anyone who uses a mobile phone can fall foul of the bill. Some nominated members have proposed amendments to the bill in committee. The amendments seem to accept the powers being given to ministers to be the arbiters of truth and public interest, but attempt to scope them. The amendments also ask for more transparency and for an independent advisory council. While I appreciate their intention and efforts to try to mitigate the dangers of the bill, the Workers' Party objections are more fundamental and require us to reject the bill. For my part, I will focus my speech on the following concerns. 1, the limited role of the courts under POFMA, and 2, why POFMA may endanger the national interest. First, limited role of the courts. The Workers' Party Secretary-General MP Pritam Singh had earlier set out why the party believes that the POFMA powers to issue directions should be vested in the courts rather than ministers. The government, on its part, has been stressing that ministers are circumscribed by an appeals process and judicial oversight. It is important to examine the details of this. First, let us look at appeals. Appeals are basically requests to re-look at the original decision on the merits to decide if the decision was right or wrong. Under what circumstances can appeals be made to the High Court? The bill has explicitly restricted the grounds of appeals against ministers' directions. Under Clause 17(5), for example, it is provided that the High Court may only set aside a Part 3 direction on any of the following grounds on an appeal. A, that the person did not communicate in Singapore the subject statement. B, that the subject statement is not a statement of fact or is a true statement of fact. Or C, that it is not technically possible to comply with the direction. These are the only 3 grounds on which the High Court can set aside the minister's directions. The burden of proof falls to the individual to prove that his statement was true. This is potentially very onerous due to information asymmetry between government and individuals, a point I shall return to later. The appeal to the courts is thus very tightly scoped. The High Court cannot inquire into the merits of the decision, whether in the court's view the decision should have been made in that way. On an appeal, the court, for example, cannot ask important questions such as A, is the minister overreacting? B, did the direction impose obligations on the communicator which are excessively onerous or harsh? Or C, does the public interest require the direction to be issued? So the government has argued that the courts can look, in fact, into proportionality and into the question of public interest. The argument, as I understand it, is that these matters can be looked into under the usual judicial review route. So let us look at judicial review. I agree that POFMA does not carry a clause ousting judicial review of ministers' decisions, so judicial review exists. But what does judicial review mean? First, judicial review is a public law remedy which requires the individual to take out a separate legal action against the government, usually by suing the Attorney General as the government representative. In order to do this, the person must first apply for leave or permission from the court to commence a judicial review. If leave is obtained, the judicial review application can then be filed. These steps will take time. 2 sets of legal costs will thus be incurred. The litigant will also be facing the formidable Attorney General's chambers with limitless resources to defend the government. There was no mention by the ministers yesterday that the judicial review process would be made simpler or cheaper. Secondly, in a judicial review, the court is not looking into whether the minister's decision is right or wrong. The purpose of judicial review is to determine if the minister's decision is legal and rational. Therefore, if a minister asserts that a correction direction is needed in the public interest, the court cannot delve into the evidence to weigh up whether the direction should be issued or not. So long as the minister's reasons are in line with the purpose of the Act, the court will generally not interfere. Judicial review is thus a difficult proceeding to mount and to win. Looking in totality then, it is my assessment that the powers of judicial oversight of ministers' powers under POFMA are severely limited. Next, why POFMA may endanger the national interest. So the government should not assume that Singaporeans who criticize or query it are malicious. Criticisms and queries may well arise out of genuine concern and provide opportunities for detailed and measured responses. If we wish to imbue citizens with a real sense of ownership, we should focus on empowering minds and hearts with knowledge. This knowledge should not just come when falsehoods emerge, but on an ongoing basis. The government has confirmed that it agrees that arming citizens with knowledge is a powerful weapon against falsehoods. To this end, the government should do some introspection as to how it may itself have contributed to the spread of falsehoods by its control of information. One past episode on how incomplete information may lead to erroneous conclusions happened 15 years ago. 2 economists were rebuked by the government for putting up job figures, suggesting that the majority of new jobs were taken up by foreigners in the previous 5 years. This was strongly refuted by the government, which then released statistics previously not disclosed, showing that, in fact, for every 10 jobs created, 9 went to residents. The 2 economists were labelled as irresponsible and unprofessional. In their defence, they said that they had taken their initial figures from the Ministry of Manpower's website, while the newly released figures were information they had no access to. If the same had occurred after POFMA was enacted, would the professors be required to tag corrections to their reports online? How would their professional standing thereby be diminished in the eyes of their colleagues, students, and the world at large? Worst of all, would they and other economists choose to steer clear of researching or writing about Singapore to avoid such backlashes? If so, Singapore would be the poorer for it. So the government has been trying hard to convince the public that fears about the bill having a chilling effect on the freedom of speech are unfounded. How convincing is this? The bill is not only targeted at deliberate falsehoods, but at all statements the government deems false, even if innocently communicated. Under clauses 11.4 and 12.4, it is stated that correction directions may be issued by the minister or the alternate authority, even if the person who communicated the statement did not know or had no reason to believe that the statement is false. The minister or the alternate may even require the correction notice to be published in print form in a specified newspaper, which cost will have to be borne by the person concerned. As it would be up to the minister or the alternate to specify the size of the correction notice, the person will have to buy the required space from the newspapers, which could easily run into thousands of dollars. The government says that it is giving assurances in Parliament that will be recorded in Hansard, and other controls will be enacted in subsidiary legislation. As POFMA is a law that potentially catches all Singaporeans who use digital communication, the government should make the law as clear and accessible as possible. Is it reasonable to expect an ordinary citizen who wants to understand POFMA to have to cross-refer from the Act to subsidiary legislation and then to the parliamentary debates as well? Finally, sir, before I end, I would like to address briefly the issue that was debated earlier about having the courts as the first arbiter and the issue of speed. Earlier, there was discussion about whether the courts could respond quickly enough in certain situations. Now, as debated by my party colleagues earlier, we believe that this is a matter of how the courts are resourced and how the processes are streamlined. So we believe that it is possible if there's political will to do so. Secondly, the government is a very powerful government with a lot of resources. And if the government wishes to correct any statement that is floating online, it does not have to wait for POFMA. It has many channels of communication at its disposal, through the mass media, through its own internet channels. I think more than sufficient to get its information out to combat the effects of any falsehood as it deems it, even if it has to wait for POFMA adjudication. And finally, sir, at the outset of this debate, I think the minister made clear that he or the government already has very vast powers under other laws. And POFMA is a voluntary scoping down of government's powers. So, sir, in totality, I do not believe that the government will be helpless if POFMA requires the courts to be a first arbiter in this respect. So finally, sir, to conclude, we have grave objections to POFMA and the damage it will do to Singaporeans who wish to debate and discuss current affairs and topics of national importance. POFMA is lopsided and gives the ministers too much power in matters where they may be interested parties. We oppose the bill.
Associate Professor Daniel Goh.
Mr. Speaker, sir, the aim to protect Singapore from deliberate online falsehoods that could undermine the democratic foundations of our society is acceptable and good. But this POFMA bill gives the government of the day massive targeted powers that go beyond this remit, and is therefore not acceptable and not good for Singapore in the long run. It has been said POFMA balances the right and utility of responsible free speech with the necessity for speedy action to prevent the subversion of society in the informational age. I disagree. In my view, this bill is severely imbalanced. Speed is a key premise for POFMA. Speed is distance over time, and the government has chosen to maximize speed, giving itself great powers to cross vast distances in a short amount of time. But this need for speed can have severe detrimental effects for society and the state itself if it's not properly checked. I shall deal with three issues. One, the problem with the definition of falsehoods in the hands of the executive. 2, the problem with the government defending public confidence in the government itself by force. And 3, the government choosing between a legacy and a Trojan horse. Ministers deciding on facts and falsehoods. The first issue concerns the definition of falsehoods in this bill. The definition in Section 2 is double-barreled. First, a falsehood has to be a statement of fact. Subsection 2A states that a statement of fact is a statement which a reasonable person seeing, hearing, or otherwise perceiving it will consider to be a representation of fact. This definition rests on the figure of the reasonable person. I just want to note a paradox here. As elaborated by the Minister of Law in his opening speech, the problem we face today is that online falsehoods have undermined public discourse and eroded precisely this figure of the reasonable person. Whether a statement is a fact or is an opinion goes to the heart of this piece of legislation, as it provides the scope for which statements could be covered by the law. If the reasonable person does not quite exist anymore, how do we determine if a statement is indeed a statement of fact and not an opinion? The fact that the Minister for Law had to go to great lengths to clarify with detailed examples on what are statements of fact and what are statements of opinion show that this distinction between fact and opinion has significantly blurred in public discourse. It is well defined if a statement of fact is an established matter in jurisprudence, but we're talking about placing the powers in the executive here. If the reasonable person in the juridical definition of the statement of fact has indeed faded away, how would the executive, especially the ministers, being not the judiciary steeped in matters of jurisprudence, be able to distinguish between a statement of fact and a statement of opinion in a speedy manner? This is an important issue, since a wrong application of a correction directive on a statement of opinion can be a miscarriage of justice and even affect electoral results. Ministers have to be extremely cautious even at the first step of the process to determine whether a statement is a statement of fact or a statement of opinion. The only resolution I can see is that ministers will have to consult the Minister for Law on this determination, and this will take time, perhaps as much time as a court will have taken to decide on the correction order. Let me come now to the second part of the definition of falsehoods, which has itself 4 subparts to it. Subsection 2b states that a statement is false if it is false. That sounds a bit tautological, but I think it can stand. False or misleading, whether wholly or in part, and whether on its own or in the context in which it appears. The definition of falsehood should be simply based on fact. A fact is something that is known to be true because of existing information or proven to be so by current evidence. Conversely, a statement of fact is false when it can be shown to be true, not true by information or evidence, whether existing or new. Let me repeat that again. Conversely, a statement of fact is false when it can be shown to be not true by information or evidence, whether existing or new. To add the term misleading here is dangerous, as it opens up the judgment of truth to multiple interpretations of connotations and implications. Furthermore, how can we justifiably and reasonably make people responsible for part of their statements and for statements taken out of context? By this definition, a statement can become misleading by virtue of being interpreted in the worst possible way, whether wholly or in part, whether on its own or in context. So does this mean that the government can take a statement I make, quote a part of it out of context, choose the worst of all the possible interpretations of the partial statement taken out of context, and then accuse me for misleading the public on a matter of public interest? Public confidence is earned and not enforced by the government. The second issue has to do with the meaning of public interest in Section 4. I have little quibble with the list of areas A, B, C, and E. I have reservations about D with regards to elections, but I'll focus on F. I object to F, which has to do with the public confidence in the performance of the government. Subsection F is worded as, to prevent a diminution of public confidence in the performance of any duty or function of, or an exercise of any power by the government and organ of state, a statutory board, or a part of the government, an organ of state, or a statutory board. I would like to ask which part of life in Singapore is not covered by this incredibly sweeping sub-definition of public interest? This sub-definition makes any disputed statement of fact that merely risks reducing some public confidence in the performance of any action by just a part of the government and statutory boards liable to this law. This is practically any statement of fact critical of the government. Other than takedowns for posts that endanger our national security, foreign relations, racial and religious harmony, public safety, why is there a need for speed for all ministers, to impose corrections on alleged falsehoods about the performance of the government. Where is the sense of proportionality here? I'm not saying that the government shouldn't act to clarify and correct widespread falsehoods that could undermine public confidence in our public institutions. I'm saying that I do not see the need for speed to force a correction, as the current supposedly slow practices of correcting falsehoods already work to great effect. Let me give two examples. The first is the case at the beginning of this year, when there was a public online furor over claims that the government had quietly raised the CPF payout eligibility age from 65 to 70 years old. This arose from a misunderstanding arising from the setting of the automatic payouts at age 70 instead of 65. I believe that automatic payout should be set at the payout eligibility age, but that's my opinion. But factually, it was false. The government quietly raised the payout eligibility age. This was corrected by the government, by press statements and parliamentary answers by the Minister of Manpower in response to questions from members, which was then carried by the media. This falsehood spurred the government to redouble their public education efforts, producing good materials to educate the public on the policies, which effectively dispelled the falsehood. The second is a recent case accusing the police of preferential treatment for letting off a male undergraduate for filming a woman in the shower in an NUS hall of residence because the student's parents were well connected to powerful people. This example was also cited by the Minister for Law in his speech moving the bill. An objective press statement by the police setting out the facts dispelled the falsehood. As a result, many were chastised by fellow online citizens for spreading baseless assumptions. Furthermore, the way the police went about dispelling the falsehood earned praise from the public, as the police respected the privacy of the offender and obtained permission from his family to review their background. Again, supposedly slow methods worked effectively. These two examples show us that public confidence in the performance of the government has to be earned and cannot be enforced. In these two examples, the government is engaging Singaporeans as a partner in conversation. In these two examples, the government is not arbitrating truths ex cathedra, using its authority to force corrections and threaten mistaken citizens with punishment. Instead, it is calmly explaining the facts and issuing additional information so that public confidence can be restored and even improved. There is no need for speed. In fact, timeliness and proportionality are key here, not speed. In fact, the responses from the government was not slow at all, and it was not hasty too. It was timely. No need for speed. Times have changed. The online public dwells in an information-rich environment and has its own norms and etiquette in engaging with debate and discussion. Trust in the government is no longer built on the good performance of its duties alone, but on communication and public engagement by the government. Educated citizens want to be engaged as peers by the government. As such, the government, acting as a party in contentious politics with the online public, will erode public confidence in the government in the long run. Giving the ministers, and by extension the civil service, the powers to force corrections, create an easy and speedy way out from the hard work they should be doing instead, which is earning their trust through time-consuming but ultimately fruitful engagement with the public. I don't understand why the government will want to protect the ministers from the test of fire of public reason. Leave a legacy, not a Trojan horse. I now come to the third issue, which represents the Workers' Party's fundamental objection to the bill. This law is an important one because it will set the tone for generations to come. I believe, as do my Workers' Party colleagues, that it is best to leave the arbitration of truths to the courts and not have the executive or the government sullied in mud fights with the public over falsehoods, and worse, leave Singapore society wide open to abusers by a thin-skinned executive protecting its own institutional interests. We believe that the courts should be the place to arbitrate truths and correct falsehoods, because the courts are the natural place to do this, since this is exactly the function of the courts, to use a reason and objective test to judge what is true and what is false. The executive or the government works with truths, but it will have its blind spots. In other words, the executive, like many other organizations in society and civil society as a whole, is an interested party in the determination of truths. Of course, as the executive of the government, it upholds the general interest of society. The executive has a lot more capacity to obtain information and generate knowledge. Though it does not have the monopoly on truths, the executive is first among equals in knowing and working with truths. It is the responsibility of the executive to share its depositories of knowledge and truths with the public, so that together with the informed public, the executive can correct falsehoods that could undermine our public institutions. The The government should focus on co-correction with the informed public, not the unilateral correction of falsehoods by ministerial fiat. It is a star player in the football team, the captain even, but it should not be the referee. I do not agree with the very notion that the courts are the final arbiter of truth in this law, because this means that the executive of the government is the initial arbiter of truth. The executive should not arbitrate the truth. It is not its place to do so. If it does, it undermines our collective faith in truths in the long run. Should the executive exercise the powers given in this law, it will short-circuit the process of co-correction with an informed public, which I just described. In doing so, the executive forces the truth. Let me say it again. Forces the truth onto the public. It does not arbitrate the truth. The argument to give the executive these draconian powers of forcing the truth on the public is that the executive needs speed to act quickly when it comes to exigent matters of public interest. But there is no reason why the process of applying to the court for corrections and takedowns cannot be sped up. If the government can speed up the appeal process in this proposed regime, and for the POHA interim protection orders, then there is no natural obstacle to do the same for the alternative process of making the executive apply to the courts for corrections and takedowns. The need for speed in certain areas can be met without misplacing arbitral powers in the executive. But when it comes to public confidence in the performance of the government, there is absolutely no need for speed. Public confidence is a long-drawn affair. Less haste, more effectiveness. Heterodoxies, which may be extremely uncomfortable for the government in the short term, are often useful and beneficial to public institutions in the long term. Many times, the heterodoxies will not go away. And the more authorities try to forcibly protect the orthodoxy, the stronger the heterodoxies grow. Sometimes the heterodoxies turn out to be true, once the full force of information and evidence decide the matter. The only right approach is continued public engagement and public education by the authorities, the efforts of which in themselves will help to show up public confidence in public institutions. Take, for example, the anti-vaccination movement. One strand of it grew from academic studies published in scholarly journals about possible association between the diphtheria, tetanus, pertussis, or DTP vaccine and sudden infant death syndrome, or SIDS, in the United States in the early 1980s. These studies, because of its sensational value, were reported in the media, creating alarm among the public and feeding the anti-vaxxers. Over time, medical scientists debunked many of the studies, reporting possible association, and produced studies that quite conclusively show no association between the DTP vaccine and SIDS. This enhanced scientific certainty made the public health system more robust and improved public confidence in public vaccination programs. It could be said that society took one step back and then two steps forward. But if the authorities had intervened to suppress the heterodoxy in the name of protecting public confidence in the public health system in the first place, we would have been stuck with an orthodoxy, a believed truth, rather than one we have scientific certainty of. The DTP SIDS myth refuses to die till today, but this has spurred public education efforts that have enhanced public awareness of the benefits of vaccination. Mr. Speaker, sir, this is a legacy that each predecessor government should leave to its successor, a culture of public engagement that enhances our collective faith in truths and co-corrects falsehoods with an informed public. This POFMA bill undermines such a legacy and leaves us with a Trojan horse instead. It is ironic that this government is extolling the current public confidence in it to dismiss concerns of abuse. It is saying in a circular way, thank you for your trust in us. Trust us then to use these draconian powers to protect that trust. What if future governments who do not deserve the trust of the public, or even if this government tomorrow, because they're not performing their duties well, seek to prop up the trust and deny public scrutiny using POFMA? There will be nothing to stop such irresponsible governments, for which corrections can pour out POFMA as quickly as Greek troops pouring out of the Trojan horse to see the city of Troy. What matters to us is not the assurances of the Minister for Law of restraint and reason on his part, but the substance of the law as framed in this bill, whether it is a charming but fatal Trojan horse or a true legacy of protection that deepens our trust and unity as a diverse society that goes online to discuss issues. In the same shadow of the Trojan horse, the subsidiary argument that ministers will face the public at the ballot box for wrong and heavy-handed actions is a terrible argument and poor justification for granting such far-reaching powers to the executive. It is irresponsible political brinksmanship. It is saying to the citizens, if you are not happy with my decision, I dare you to vote me out. If Singapore reaches this stage where the ministers have to be tested at the ballot box in this manner, then we are already seeing the erosion of trust in government and in the public institutions. It will be too late to turn back by then. Mr. Speaker, sir, truth and justice lie at the heart of modern political systems that are progressive and protective of the rights and livelihoods of the people. Truth and justice are not just ideals but they are pragmatic values that pervade the performance of public institutions. Truth and justice are closely related. They imply each other. The executive acts on truths to accomplish justice. The judiciary enacts justice by arbitrating disputed truths. It is clear that the protection of society and the government from online falsehoods should lie with the courts. And this is the position of the Workers' Party. We oppose the bill.
Mr. Mann.
Mr. Speaker in Mandarin, 议长先生，刚才我听了严天宝议员以及刘成昌议员之间的这个一番争论呢，我觉得刘议员他用了一个比喻，似乎有点暴力，所以在这里我想稍微澄清一下。其实我觉得这个法案里面，部长他所扮演的这个角色，应该说是有奏无斩。怎么说有奏无斩呢？因为其实它的作用就是要让大家知道说，如果这个真的是假信息的话，这是假的，予以更正。那么原本的贴文在绝大部分的这个例子当中都可以保留，何斩之有呢？不过呢，我觉得工人党的议员们他们所提出来的要求部长先向法庭提出申请，然后再做定夺，其实之前部长他们在这个论述里面都已经解释了，网络假信息它的分布、它的散布是非常快的，所以呢，这个等于就是拿远水来救近火。我觉得我们今天的辩论呢，就是要辩这个，我们是不是要拿远水来救近火
Mr. Low.
Okay, first, 首先我先讲你第二部分的说远水救近火的问题。刚才我们的主席刚刚演讲的时候说过，当部长在国会演讲的第二读演讲的时候已经说了，其实政府有很多法案、很多权利可以应用。目前这个 POFMA 这个立法呢，只是其中一个小的部分。所以没有所谓远水近火的问题，政府原本就拥有一定的权利，可以在任何时候，如果在有假信息出现的时候，就可以马上采取行动。至于是斩还是不斩，我的答案是斩。为什么呢？因为部长可以决定怎么样进行怎么样的行动。刚才我们主席也说过了。在这种情况之下，好像过去的那两个经济学者的话，他们所受到的损害是很大的。如果部长说哦，你必须要做出澄清的话，在网站上面，所以呢，之后再向法庭上诉啊，就好像是被斩了、行动了，再向法庭投诉部长的不是，那个就是申冤哦。但是申冤又怎么样呢？斩已经被斩了，冤已经被冤了，所以我们呢就认为不应该先被斩或者被冤，应该先上法庭，由法官判断之后，才做一个定夺，这才是正确的刑事告。
Mr. Mann.
Mr. Speaker in Mandarin， 我觉得现在我们已经达到了这场辩论的一个重要的主题。其实我觉得是一个规模方面的混乱。我认为工人党的议员们呢，其实他们在辩论当中都尽量的要把这个假信息它所带来的深远的影响的规模，同比方说个人的一些言论它的这个规模呢，把它混在一起。其实这两者是完全不一样的。如果您有仔细的听我们的这个特选委员会它的报告里面所讲到的这些假信息所带来的祸害和影响，这是排山倒海的，排山倒海的。因此，我说用远水来救近火，就是这样子的一个意思。我们要在比方说这个假信息散布，影响到社会，影响到安全，在这么严重的情况之下，难道我们真的还要去找远水来救这场近火吗
Mr. Low.
Clarification in Mandarin， 刚才我已经说得很清楚了，政府原本就在各个法案之下拥有一定的权利，甚至可以关闭网站。刚部长有讲得很清楚，他在开场白就讲说，政府在各个法案他给了一个清单， 某一种法案，政府都有这个权利可以去进行阻止这一些人的假信息的传播嘛。他说 POFMA 只是其实呢，这个是比较小的武器，还有更大的武器，所以这个时间即使是有问题的话，很紧急的话，政府还是有权利。所以不关大小的问题，政府本来就有权利可以制止假信息的传播。
Mr. Mann.
Mr. Speaker, imagine again. 议长先生，其实我觉得这场辩论越辩越离奇了，因为共产党的朋友们似乎觉得政府呢有这一些全世界最先进的政府或者社会都没有拥有的武器来对抗这个假信息。其实我觉得可能刘议员真的是没有仔细的去了解我们的特选委员会的这个报告。其实我们所谈论的这些假信息，这是席卷全球的问题，而且呢，这是许许多多的国家和社会都感觉到措手不及的问题。那么，如果您觉得说现在我们的政府已经拥有了可以马上制止假信息的这些手段，或者有这一类的这个法令的话，那么这场辩论岂不是变得毫无意义？
Mr. Low.
Mandarin Sir， 我们的秘书长就在那个委员会里面，所以他有告诉我们委员会的讨论的内容，所以我们对委员会的内容有一定的了解。这个假定机的这个问题呢，其实呢，根据我们所知道，以政府现行的立法也可以做得到。你可以关闭那个网站啊 ，Facebook 根据 can close Facebook right？If they want to， 你可以关掉 Facebook 啊，如果你真的要的话。不过你的总理的120万个粉丝就没有作用了啦。所以问题是你能够做得到，只是你要不要做而已，不需要一定要通过 POFMA。如果你说时间很紧急的话。
Unless there's any fresh perspectives, I suggest we move on.
议长先生，我觉得刚才刘议员这一番话不攻自破。那么我这样说好了，您既然对这个报告书的内容这么了解，是了解还是曲解？我们且听下回分解。接下来我们还有很多机会，我相信我们一定会把这个问题变得比较明白。
Mr. Leon Pereira, should you speak?
Mr. Speaker, sir, all members in this House and both the Workers' Party and the People's Action Party agree that fake online news is a danger that modern societies must address. We have seen what happens elsewhere when falsehoods fan sectarian hatreds, swing elections and harm national security. We need tools to limit the reach of truly dangerous falsehoods spread by malicious actors. But while we agree on the goal, the Workers' Party and the People's Action Party disagree about the means to achieve that goal. We disagree because we look ahead to the future of this country after this bill is passed. And we see a country where too much power is vested in the hands of any and every minister. We see a country where free speech, debate, and thinking could become stifled, especially on the very important matters of public policy and politics, on which so much else in national life turns. We disagree because the cure that the PAP government has placed in front of us could lead to outcomes worse than the disease. As the Honourable Member Mr. Pritam Singh said, Section 2 of POFMA defines falsehood as statements of fact that are false or misleading, not false and misleading. So a misleading statement can be deemed false by a minister by virtue of omission of facts. Sir, in political, intellectual, legal, academic, public debate, individuals often present facts that support their arguments and devote less time and space to facts that tend to support the opposite argument. This has been the case for centuries. Yet Section 2 suggests that a particular collection of facts may be construed as misleading if the, quote, opposite facts, as it were, are not given what the minister thinks is sufficient weight. The same minister may not correct statements made by the government or its supporters that present mainly their facts, as it were. How do we deal with statements like this? For example, HDB flats are more like rental flats than owned assets since lessees lack strata titles. The HDB controls many aspects of what you can do with your flat, and the value declines over the long term towards $0 at the end of 99 years. Sir, Minister Lawrence Wong denounced a similar notion as legally and factually wrong. Would such a view be deemed subject to a correction order under POFMA? Under POFMA, a falsehood can be deemed grave enough to warrant correction or penalties for being a misleading collection of facts, even if it does not contain one single false statement of facts. If this wide definition of misleading facts is maintained, the courts should at least be the first arbiter of truth in respect of formulations such as this one, rather than ministers who have and who will be seen to have their own political interests, a point I will come back to. Next, Section 4 sets out various criteria by which false statements are deemed harmful to the public interest. However, the language lacks any reference to a real risk threshold. In Section 4, it would seem that anything that impinges on national security, public health, public finances, and so on, in however microscopic or indirect a manner, would be upheld as vulnerable to corrections or penalties. The language of Section 4 states expedient and necessary, but expedient and necessary for what? To what degree of harm to those things? Shouldn't Section 4 be worded to define public interest with reference to a real risk posed to the things described? In lieu of this, any statement having however minor an impact on the things described would qualify as correctable. How could meaningful judicial review thus operate? And this is setting aside Section 17, Part 5 circumscription of the scope of what has been said will be fast and cheap POFMA High Court appeals to exclude consideration of the degree to which public interest is impacted, a point which my colleague Mr. Dennis Tan and which my party chairman Ms. Sylvia Lim will expand on. This lack of a threshold of significance raises the risk of abuse of POFMA powers to correct matters which have a very minor impact on the public interest. Next, my colleagues have spoken about the chilling effect POFMA may have on free speech. This is not political point scoring. It is by virtue of this bill's peculiar cocktail of three things, of Section 2, defining what a minister deems a misleading presentation of facts, not only false claims of facts, as correctable. That's one. 2, Section 4F, defining harmful falsehoods as including those that diminish confidence in the government. And thirdly, Section 6, which establishes ministers as the decision makers of truth and falsehood in the first instance. It is true, the combination of these three aspects of POFMA, that this bill is likely to chill free speech and debate about government, policies and politics, particularly expressions of views that run counter to the government narrative. Why do I say this? Look ahead to the future. Correction and takedown orders could damage, if not destroy, reputations and careers for journalists, activists, academics, public intellectuals, politicians, professionals of various kinds, in fact, for many, many citizens. If your post becomes subject to such orders, what would your employers think? Your lecturers and tutors? Your professional colleagues? Your friends? Your spouse? Your business associates, partners, and customers? When we bring in the risk of massive fines and lengthy jail time under Section 7 for a single offense of, quote, having reason to believe, unquote, that one statement is false or harmful as POFMA defines it, which includes undermining confidence in the government, and with no threshold of significant impact on public interest specified in the law, the risk, Mr. Speaker, sir, is not just of chilling free speech, but of hurling it into an industrial freezer. By free speech here, I refer particularly to public speech regarding policies and politics that may contain criticism of the government of the day or the ruling party. I note in passing that for offshore sponsors of deliberate online falsehoods like state actors or offshore extremist or sectarian groups, it would be difficult, if not impossible, to subject them to these criminal penalties. The burden of these penalties and the fear they generate will fall primarily on domestic actors, on Singaporeans. Of course, penalties for harmful falsehoods are necessary. I want to be clear about that. But when the penalties are severe and attached to language like that in Section 2 and 4, and with ministers as the first arbiters of truth, the prospect of chilling public political debate is very real. What would Singapore look like if most Singaporeans avoid commenting publicly in ways that may be seen as critical of the government and its narrative? What may take hold is self-censorship and the restriction of online comments in favor of verbal conversations among friends or talks held among small groups. And the reason for this is clear to see. Many citizens will not have the stomach to risk a correction order or a criminal charge, even if they are confident about their facts, as many will not want to take on the effort, time, cost and risk entailed by a legal appeal, let alone a full-blown judicial review action. Under POFMA, the burden of proof falls on the person saying something, not the government for saying that that something was false. Many will choose not to take up that burden and simply not speak up. Next, Section 11 raises a related issue. Its language regarding correction statements is broad. The correction statement must be worded, quote, in the specified form and manner, unquote, specified by the government. Is there any requirement that correction statements be as concise, factual, reasonable and non-pejorative as possible? Where is the requirement of proportionality in wording correction statements? Next, look ahead to the future. The price we pay for this bill may be to live in a country where alternative media activists and journalists are afraid to bring certain information to light, possibly information about lapses, abuses, scandals or corruption, because they need to protect people who have shared information confidentially but are too afraid to be named. In this case, under Section 7, potentially even the expression of a public suspicion or the publishing of information from confidential sources by reputable journalists and writers using accepted investigative and journalistic methodologies may attract criminal penalties. The POFMA bill as it stands lacks a public interest defense, something the UK is reportedly considering including in its eventual fake news law. There should be a public interest defense whereby a statement that was false, according to the strict standards of POFMA, i.e. it could have been deemed misleading at the time that it was made, may still not be an offence, or would be a far smaller class of offence carrying smaller penalties if made in good faith using a defensible process and to serve the greater public interest. So let's look ahead at the post-POFMA future. Will practitioners in the media industry and academia err on the side of caution? Does that help Singapore's reputation as a global business, R&D and knowledge hub? Will scientists and public health professionals with a different view from the government on the public health impact of e-cigarettes, for example, hesitate to publish clinical research showing harm reduction to confirmed smokers for e-cigarettes out of fear that they may be subject to a correction order because they did not also publish in the same statement facts about how many young first-time smokers are taking up e-cigarettes in the US, and hence that research would be deemed a misleading collection of true statements. As a result, will they refrain from publishing such facts due to the personal consequences they will have to face? And how does the impoverishment of policy debate that may ensue from that help the formation of good policies? How do we mitigate the risk that academics and the media may come to see a need to soft launch their ideas before publication with government officers to minimize the risk of POFMA action? Or worse yet, simply self-censor or water down outputs that may disagree with the government's narrative and hence be deemed to undermine confidence in the government under Section 4. Next, let's look ahead to the future post-POFMA in respect of politics. Singapore will be a country where any minister can determine in the first instance what is truth and falsehood. In the first instance, post-POFMA, ours will be a country where ministers with the political interests they are seen to have can correct statements they deem misleading. But the very same ministers will not be subject to the stringent, immediate and broad strictures of the POFMA law. Ministers and government spokespersons can say what they want, including misleading statements with a partisan political character. What is the restraint on the government here? Can victims of possible government falsehoods go to the POHA courts? Evidently not. They can sue for defamation, but again, how many would do that? Would defamation apply to statements made by ministries and agencies as opposed to ministers? And how long would that take? What if a falsehood affects the outcome of an election? What if a falsehood perpetrated by a government affects the outcome of an election? Would a positive defamation verdict for a victim of government fake news after the election help? Section 4F describes diminution of confidence in the government as one definition for a falsehood being harmful to the public interest, a feature of this law that is different from most similar fake news laws or draft laws in other countries. Is vesting powers this broad in the government of the day from now till this law is repealed, if ever that day comes, the responsible thing to do for future generations of Singaporeans? What if a rogue government uses these powers to stifle criticism, block the circulation of embarrassing information about lapses, abuses, or corruption, perpetuate fear, and entrench itself in power? What if such a rogue government exploited the reluctance of many Singaporeans to sue the government in court to its advantage? What if such a government exploited the lack of a public interest defense to suppress genuine and responsible investigative journalism? Do we serve future generations of Singaporeans by passing such a law and passing into the hands of the government of the day such a powerful weapon, not knowing how it might be used? When asked about the possibility of a future rogue government abusing POFMA, the law minister said, and I quote, "I cannot vouch for how a future government will act," unquote. Some would say, and the law minister also said in the same interview, I'm not taking it out of context, that a rogue government or minister who abuses their POFMA powers will be held to account in elections. And a number of PAP members of this House have made a great deal of this point. But Mr. Speaker, sir, this ignores the fact that a rogue government can precisely use POFMA powers to stop voters from learning negative information about its actions, which could be a factor in those very elections. The powers can be used to partly insulate against electoral accountability. To say Parliament is a check against abuse is neither here nor there. The abuse may affect the composition of the Parliament itself. Mr. Speaker, sir, this argument is, to a large extent, circular. Some might say that chilling free speech a little is the right price to pay for preventing foreign powers, extremists and opportunists from destroying our communal harmony or even our independence as a country. So we recognize the need for a surgical tool to fight fake news. That is why my party leader, Mr. Pritam Singh, has argued for an alternative regime, a regime where the broad definitions and powers in POFMA are curtailed by virtue of the government requiring judges to approve correction orders at the point of implementation, which is closer to one aspect of the model being debated and implemented in France. Resources can be provided to ensure that duty judges provide fast prima facie decisions in time-sensitive cases. The court should be the first arbiter and not the final arbiter. Sir, in Malay please. Tuan, rang undang-undang yang dibentangkan pada hari ini mengenai kepalsuan dalam talian merupakan satu penawar yang lebih teruk daripada penyakitnya. Kita semua bersetuju bahawa kepalsuan dalam talian adalah satu gejala buruk yang kita perlu perangi. Namun, cara yang digunakan untuk memeranginya adalah salah. Rang undang-undang ini akan membuat rakyat Singapura teramat berhati-hati untuk menyatakan pandangan kerana pandangan mereka boleh dianggap mengelirukan walaupun ianya berdasarkan fakta. Ini boleh berlaku hanya kerana pemerintah beranggapan bahawa fakta itu sebagai fakta yang menyokong pandangan yang mengelirukan dan pandangan ini menjejas keyakinan rakyat terhadap pemerintah. Rang undang-undang ini boleh mengurangkan usaha-usaha untuk menengahkan informasi-informasi yang dianggap kritikal terhadap pemerintah. Ia juga boleh disalahgunakan oleh pemerintah yang tidak bertanggungjawab. Jika ada menteri-menteri yang berkemungkinan mempunyai kepentingan politik mereka sendiri, mengeluarkan perintah pembetulan dengan cara penulisan yang boleh memalukan para pengkritik atau bahkan mengambil tindakan untuk menurunkan berita yang dipaparkan serta memberhentikan peredaran informasi yang boleh memalukan pihak pemerintah. Tuan, di bawah undang-undang ini, pemerintah membuat keputusan sama ada sesebuah berita itu boleh dianggap palsu ataupun tidak akan bertanggungjawab untuk membuktikan bahawa ianya bukan palsu, terletak pada orang yang mengeluarkan penyataan ini dan ia perlu dilakukan di mahkamah. Parti Pekerja meminta agar diadarkan undang-undang berita palsu yang meletakkan tanggungjawab untuk membuktikan kepalsuan kepada pemerintah. bukan pada orang yang mengeluarkan penyataan. Mahkamah harus menjadi penentu pertama dalam membuat keputusan keadilan dan para menteri tidak boleh diberikan kuasa yang bahaya seperti yang terdapat dalam rang-rang undang ini. Satu kuasa yang boleh digunakan oleh sesebuah pemerintah yang tidak bertanggungjawab untuk mengekalkan kuasa pemerintahan mereka. Tuan, kami di Parti Pekerja tidak membangkang atas dasar hanya semata-mata untuk membangkang. Tetapi kita membangkang apabila kita melihat sesuatu yang tidak mempunyai unsur-unsur kepentingan nasional seperti rang undang-undang ini. And in conclusion, sir, purging destructive falsehoods from the public square is the right thing to do. But this bill is a cure worse than the disease. When we look ahead post-POFMA, we see a country where only the rich and brave may dare to speak out. In time, the chill on free political speech may also affect our young people in our schools and higher education institutes. Will they come to self-censor their thoughts and their expressions to align with the government narrative? Will they internalize a fear of not diminishing confidence in the government, as Section 4F of POFMA details? What would this mean for Singaporeans becoming independent thinkers who can navigate a world of disruption? And I bear in mind what the Honourable Member, Professor Lim San San, said about how among the general public people are now using POFMA as a verb. I will POFMA you. Sir, the problem of fake news needs a surgical tool welded by objective, non-conflicted surgeons to strike at the diseased organ and not the healthy limbs. But this bill is not a carefully crafted tool. It is a blunt weapon handed to a conflicted surgeon able to cause a great deal of collateral damage to the democratic body politic in this country. The bill as it stands needs a radical overhaul, not just minor tweaks. We do not oppose for the sake of opposing, but we do oppose when it is right for Singapore, and this is one such time. Thank you, sir.
SMS Siman.
Mr. Deputy Speaker, on behalf of the Leader, I beg to move that the proceedings on the business set down on the order paper for today be exempted at this day's sitting from the provisions of Standing Order Number 2.
The question is the motion moved by SMS Siman. As many as are of that opinion say aye.
Aye.
To the contrary say no. I think the ayes have it. The ayes have it. Mr. Peng Eng Huat.
Sir, if this bill is drafted solely to target the perpetrator of hate, violence, intolerance and disdain towards another race or religion, by all means, let's do it. We should never allow such people to propagate their vile ideology in any form or manner. This world has no place for sick people with no love and respect for life, happiness and basic human decency. If this bill is also to hold those big, powerful online business accountable and responsible to stop the spread of such vile messages, by all means, let's go after them too. These money-minded companies can't have the cake and eat it at the expense of our social order, racial and religious harmony. And if this bill is drafted solely to protect our way of life, our love and respect for one another, regardless of race, language or religion, I'm all for it. But this bill is way more than that. This bill will also give a big brother government considerable latitude to silence the voice of the common man in a community where he can be at ease to express his views, opinions, arts, music, political beliefs and more without inhibition. This bill will strike fear into the hearts of these Singaporeans who are vocal and passionate about the issue they care about most, because they can be issued with a Part 3 direction even if they do not know or have no reason to believe that the fact of what they have shared in their community could be wrong. This bill will arm the minister with a nuclear option to act as judge and jury to obliterate critics and opponents of the government in the flesh. This bill, if abused, will turn Singapore into a repressive state in no time. Sir, I too subscribe to the belief that freedom of speech is never absolute. One cannot shout fire in a crowded place and cause panic and mayhem in the name of free speech. I also subscribe to the fact that we are living in a very different world now. We do need to protect the society at large from being torn apart by the rise of racial and religious tension fanned by bigots, extremists and racists. So this bill should be scoped with the sole purpose to protect the society from harm espoused by people with vile intentions. It should be scoped to hold companies which allow hate ideologies and messages to propagate in the system accountable. It should not be scoped with ambiguity to protect a big brother government from critics, political opponents, civil societies, NGOs, and online communities in the name of tackling online falsehood. This government has already amassed an arsenal of legislation to block or take down undesirable material to protect the community at large. Does it really need a nuclear option to send shiver down the spines of men in the street, uncle, aunties, academics, critics, and the society at large in the name of protecting them from online falsehood and manipulation? Sir, the ambiguity of this bill is even more telling when it comes to the business of election. The absolute power it bestows on a minister to remove information that may influence the outcome of an election cannot be understated. This bill basically allows an incumbent party who is seeking re-election the sole power to remove any damaging statement made against the party and its leaders in the name of public interest so as to contain any political fallout. The nuclear option, if abused, will actually allow the minister to influence the outcome of an election, something which this bill is designed to prevent in the first place. Who can vouch that an incumbent party, when faced with multiple battles on all fronts, will not resort to desperate measures to avoid losing power in a critical election? We are all against foreign intervention in our electoral process. The powers that be in this world may want to influence the outcome of election for whatever reason, and we should not allow them. But we are not alone, and we should work with the social media giants to stop these foreign agents from trying to influence the outcome of our elections. But the biggest fear of someone making a false statement of fact knowingly to influence the outcome of an election may not come from an individual or from an outside source, but from an incumbent party with ample resources to shape public opinion and perception at will. The biggest contributor of misleading propaganda may come from the incumbent government itself. So where is the protection against the incumbent from influencing the outcome of the election under this bill? Take, for example, at the last general election, at the 11th hour of the campaign, the PAP machinery sent a letter to the residents of Punggol East, stating that $22.5 million belonging to the constituency and transferred to the accounts of the Workers' Party-run Town Council in 2013 had become unaccounted for. The letter said it was an indisputable fact that the money had gone missing from our books, contrary to what was reported by our auditors every year. Clearly, this false statement was made solely to influence the outcome of the 2015 election. So how would this proposed bill, if it were to be in place, deal with this false statement of fact coming from the incumbent party at the very last minute and regurgitated by the state media to reach a wider audience without any fact-checking done? Let me give another scenario. What if, during an election, some insiders were to publish serious personal allegations against the top leadership of the incumbent party, questioning their integrity and character to lead the country? Under this bill, the minister, competent authority, or alternate authority can easily order a takedown of the allegations in the name of public interest, knowing very well that no one apart from the ministers, the affected minister and insiders themselves would know who was telling the truth. So would this bill be used to silence such information which could be material to help voters decide who to support in an election? Any statement made against an entity of the authority or its leadership which may not be outright false but could be misconstrued in the context in which it appears can be taken down in the name of public interest under this bill solely at the discretion of any minister without having first to prove the alleged falsehood. The nuclear option will be able to silence anyone instantly at a critical time with no immediate recourse. Sir, no matter how you dissect this proposed bill, the arbiter of truth originates from the government and its minister and the competent authority that reports to them. the Minister for Law was reported to have said, and I quote, "The courts decide ultimately what is true and what is false, and they will be the final arbiters," unquote. But under this proposed bill, if a minister opines that it is in the public interest to issue a Part 3 direction on a statement made against the Prime Minister, for example, that opinion will be taken at face value as the gospel truth, and justice would have to be served immediately. How is that even right to begin with? How is it not wrong in any sense of the law that one is judged and prosecuted for something that the court must decide ultimately if it was indeed false in the first place? This bill will assume the government is always right all the time until the court says otherwise. As the minister has cleverly put it, the court is the final arbiter of truth. And the key word is final because, in reality, the original arbiter of truth had already spoken and issued the decree for punitive action to be taken immediately. It is easy for the law minister to say, and I quote, "These ministers are elected officials and the decision they make could also be reflected by the people's vote during a general election," unquote. Sir, if an unscrupulous minister were to abuse the power under this proposed bill right before the hustings start and win the election subsequently, what can the final arbiter of truth do? And as the minister had said yesterday, the fastest time the courts can hear an appeal in this instance is 9 days, excluding weekends and holidays. There are only 9 days of campaigning, including weekends and holidays. The election will be over by then. And what if the alleged false statement of fact was not false after all and it could have influenced the outcome of the election? What would be the recourse? Under this bill, the court may not even need to rule if the minister were to subsequently agree with the aggrieved party upon appeal that the statement concerned was indeed not false. What if the minister were to decide to cancel a Part 3 direction on his own initiative days after the election is over? In both cases, no final arbiter of truth will be required. The undeserving candidate had won. Can the result of the general election be declared void then? Sir, the law minister has said in an interview that he cannot vouch for how a future government will act with this bill. But if we knew that there is a nuclear option in the bill, which could be abused in the future, why are we as legislators not doing anything about it now? Why would we want to leave a nuclear option for a future dictator to silence all dissenting voices with a snap of his fingers? As stated in the beginning of my speech, I'm all for the protection of our way of life, our racial and religious harmony. I'm also all for making the online businesses accountable for the spread of ideologies that threatens the social fabric of our society. What I cannot support is for this government to slip a nuclear option into this bill to protect itself in the name of tackling online falsehood, especially in the context of conducting a fair election. When we enact bills that chip away our basic rights and freedom in the name of protecting the society at large, we have to be wary about the added power we will be giving to the state in the process. That power in the wrong hands may kill the dreams, the imagination, the laughter, the creativity of the people. This bill, in the hands of a despot, will kill democracy over time. The fact of the matter is, no one can vouch for how a future government will act with this bill, not just the law minister. I cannot with a clear conscience support this bill.
Minister Shan.
Thank you, sir. Mr. Singh, recommendation 12 opens with the government should have the powers to swiftly disrupt the spread and influence of online falsehoods. The government. The government should have the powers. And the objectives should be achieved as follows. Provide access to, limit or block exposure, disrupt the digital amplification, discredit the sources. And that it goes to set out these capabilities should be able to apply to all relevant platforms. And it goes on to say legislation will be needed to achieve the above objectives. Such legislation should have the following objectives. Measures will need to achieve the objective of breaking virality by being effective in a matter of hours.
on the face of it, the recommendation is that the government should have these powers. Second, the opening words cannot be any clearer. The government should have the powers. Second, equally importantly, let's not argue with qualitative words. Courts can move fast. No reason why they cannot move fast and so on. Let's stick to the clear recommendation, matter of hours. You are a lawyer. I've been in practice. Do you think in every case that is necessary, the court can decide in a matter of hours? You know the process. It will have to be filed. It will have to be served. The defendant may wish to come to court and say, I want to argue this, which means due process. How long do you think it will take to get a duty judge? I'm sure you have tried. I don't know whether you have tried, but over 22 years I have tried several times. It can take 2 days. If the duty judge is in a hearing, it can take up to end of the day. This select committee would have been mindful of all of that. It is not possible for you or for me or for anyone else in this House honestly to say the courts can do this in a matter of hours. That's just plain wrong. It's not possible. So let's stick to the select committee recommendations. In a matter of hours, 4 hours, 5 hours, what if it's a weekend? You know how long it takes to get a duty judge? When are you going to get a duty judge? When courts reopen. Sometimes you can go to his house and see him. But, matter of hours, what if he is engaged in something else? He can only give you the time that he can. And it's possible that the defendant will turn up. You can't say all the time it should be ex parte. You've got to give, even in ex parte, there is such thing as contested ex parte. If it's a responsible or respectable party, like a platform, you could say, the platform turns up and says, no, we want to argue this case. Due process means you must allow them to argue. That means you must set a hearing date. How long do you think that will take? So, POHA, the process is as follows. We have set up dedicated courts, but we have not pretended that at POHA it can come within a matter of hours. It may not be possible. But private interests in general, we think they can go and try, but it might take, we hope that it can be done in 2 days in sufficiently suitable cases, hopefully a day sometimes, but there will be other times when the judge is not available. That is why this recommendation 12, which is a critical recommendation, says the government should have the powers to swiftly disrupt the spread and influence of online falsehoods. And it says it should be done in a way to achieve the objective of breaking virality by being effective in a matter of hours. If anyone in this House says that a court, you guarantee that a court will decide every single time within a matter of hours when you need it, you're not telling the truth. And I will say so by looking you in the eye. The courts will tell you that's not possible. So let's not use words like courts can decide quickly. Of course they can decide quickly. But as I said to the NMPs yesterday, what does that mean? These are qualitative words. We are talking about hours. I've given concrete examples where things happen within a matter of hours. Private interest, you cannot have any other way other than going to court. We set up a dedicated set of courts for the state courts. We ask them to set up a separate tribunal, but that doesn't mean that order can be obtained within a matter of hours. We can do the same thing in the High Court, but that doesn't mean a court order can be obtained within a matter of hours. You just think in terms of the process. There might be times when there is no defendant, and you can try and get an ex parte, sometimes over the phone, but often there's a platform where these things are carried.
and the platform might want to be heard. Facebook or Google or somebody else. So I think the Workers' Party should try and clarify without using subjective terms and bringing in POHA, which is quite different. POFMA, this bill, together with the Select Committee recommendations, are you walking back on it? Are you saying you no longer stand by it? And if you stand by it, how does your current position make any sense? Because you accept there is a serious problem. You accept that something has to be done. Government must have these powers. It must be broken within a matter of hours. The only difference that I see between you and us is now who makes that initial call. And your method doesn't gel with what the recommendation says. So maybe I can hear from you. Thank you.
Mr. Singh.
Thank you, Mr. Speaker. I think a number of points made by Minister. I think first has to do with my position on the committee and the recommendations per se. I don't think it's an attempt to try and wiggle around the words. The government should act swiftly. Legislation should be given, should be provided to the government, and I think POFMA is the legislation that the government has put forward. I think the issue is really response time. I think that's the key pivot that the government and the Workers' Party have.
And that it says the government should have the powers to swiftly disrupt, and says this is the way it should be done.
The Select Committee report, we went through several revisions of it. I was part of a team that looked at recommendation 12 closely. I do not want to share what the deliberations of that small group were because those are confidential, and I don't intend to abuse my parliamentary privilege for that purpose, but I have those emails. I don't intend to read from them. But very clearly, my decision to remove the executive was made quite clear as the decision maker in the original draft. And I think that's the point. The point is, I believe the Select Committee had to put forth an approach to deal with how we're going to deal with the problem. But as to the specific modality, I think that was something for Parliament to decide. So that's dealing with the Select Committee's phraseology and how the issue was put out. Let me deal with the second set of issues that Minister spoke about, which was about speed. Certainly, there appears to be two regimes when the government needs to apply for an interim order, to move quickly against either an individual or a company. In this case, let's say a tech company like Facebook. And yes, I would agree that if it came to a tech company, I would expect them to challenge what the government wants to do. But in that sort of situation, the fact is, POFMA gives advantage to the government. The prima facie case is something that the judge can rule upon as a matter of course. That means the order is given, but as to the arguments that have to be dealt with later, these can be dealt with accordingly. Let me just read from the Act. I'll give an example. If the Minister could just bear with me. Targeted correction order is issued to, this is section 21, or clause 21, I should say, part 4, is issued to the internet intermediary that provided the internet intermediary service by means of which the subject material has been or is being communicated in Singapore, requiring it to communicate by means of that service to all end users in Singapore. And then it goes on to say a statement, a specified statement, and so forth. Now, we look at the identical option under POHA for an individual or company. There is a requisite standard, which is the prima facie standard. Once that standard is met, let's say by a duty judge, the question of hearing the arguments can be dealt with later. And I think this is the point which suggests to me that there is some scope for the courts to deal with the urgent issue that the government wants to resolve, at least in the interim. And then when it comes to the proper hearing, the government can make its case in full and the aggrieved party will have a time to respond.
Mr. Singh, that doesn't quite answer the question. On recommendation 12 and whether executive is mentioned or not, I think we stick to the wordings here because I'm also aware of those emails. And I think it's quite clear what recommendation 12 says, but I don't want to put you in any sort of embarrassment on that. Let's just deal with the hours point. I think it's unarguable, prima facie or whatever. The starting point is for you to file and get attendance before a duty judge. You would accept that that's not always possible a matter of hours. And that's the first point I make. Second point I make is this. If you serve it, as sometimes you will have to, particularly if, say, you decide to make the platform the defendant, and they turn up, and they say, no, before you make a prima facie order, we want to make an argument. We want to be heard. What happens? The court, are you sure, will each time make a decision within a matter of hours, assuming you can even get the judge. If the judge is in a hearing for the whole day, you get to see him at the end of the day, if he wants to see you, if he is able to see you. I think it's a simple point, Mr. Singh. It's unarguable, isn't it, that there will be times that you cannot guarantee that if you go down this route, you will always get it within a matter of hours, prima facie or otherwise. That is the only point. I mean, if you're good enough to accept that, I think we can move on.
First point, Minister, it's no question of an embarrassment for me. I think I'm quite clear as to what I think is the appropriate position taken by the Select Committee report. Decision-making was not explicitly stated which would be the entity, and I think I want to leave it at that. Second point, I think it's an important one Minister makes about, first question was in a matter of hours. And I think the Minister makes a fair point in the case of a duty judge. I mean, if indeed there's only one person, then really it comes to a question of should that be increased? Should we have more duty judges? Again, it's an arguable point. Minister may say, look, it's going to be quite difficult to execute in practice. I happen to think that, again, depending on how urgent the problem is, how bad the situation is, that can be dealt with. The second point about service, it's an important point because it deals with issues of natural justice. It's an important point. Again, we look at POHA and interim orders, for example. Clause 16 says, an interim order takes effect in respect of the respondent, and this is individual or company, when the order is served on the respondent in such a manner as may be prescribed. But critically, B says, when the court dispenses with the service of the order, let me say that again, where the court dispenses with the service of the order, when the service of the order on the respondent is dispensed with by the court, or at such a later time as the court may specify. Again, it suggests to me that the regime can be dealt with to deal with the problem of that falsehood, provided that prima facie threshold is met. Serious problem, serious falsehood put out there, and the court may decide, look, I think service is of a second order right now. We need to deal with this problem, but parties will have to come back before me.
Yes, Mr. Singh, I think let's try and get clearly. The first point is not just a question of resources. Judges have cases. It's not as if there's one judge sitting there doing nothing else but waiting for the government to come in and apply. There's a duty judge regularly to hear urgent cases. Week after week, the duty judge changes. Sometimes it carries on. And as I told you, there can be weekends, there can be public holidays, there can be other issues. The simple point is neither you nor I nor anyone else can guarantee that it can be gotten in a matter of hours. I assumed you had practiced in this area, but if you hadn't, I'll make that point to you. Second, in terms of service, if it is a known platform and there is an identifiable defendant who is not a rogue party, when you go to the court and the court says, why haven't you served on this party? Why aren't they before the court? What do you say? Okay, let's say we make provisions in urgent matters, we can come and get an interim order in the first place, even before service. Assuming, we provide for that. Then what really happens is each time you just go and get an ex parte order. All that the judge has is what you are giving him, and he confirms that you should get the order. Now, even then, after you get the order, you're going to break the virality within a matter of hours, as opposed to an immediate order by the minister. I think you have an insuperable problem there because of the availability of the judges. And if your point is each time the government wishes, it goes ex parte because it's urgent, then how is the court substantial check other than the fact that the government puts an affidavit, explains it and says, I think it's urgent, and the court gives it? But my fundamental point is, are you sure it's done in a matter of hours? Are you standing here as a party and guaranteeing that every time it happens, it will be done within a matter of hours? If you say that, we'll just leave it at that, if that's your position.
Thank you for that, Minister. I think it requires a caveat, of course. A caveat is important, and that caveat is there has to be capacity for a duty judge to be available at that time. That's the caveat.
Okay, let's move on. Mr. Leon Pereira.
I'd like to pose a clarification to the Law Minister. Sorry. I had intended originally to pose the clarification to Mr. Cedric Foo, but I think in light of the Law Minister's comments on this point, I'll just pose some clarification to him. And it is quite simple. Is it the position of the Law Minister and the government that our courts could not be sufficiently resourced, structured, if necessary a new process, a new expedited process created, if necessary a new process for assigning judges created, additional capacity created? Is it impossible, is it inconceivable that this could be done in the future in order to issue interim, prima facie decisions in urgent, time-sensitive cases under POFMA? Is that impossible? By definition. By definition, is that impossible in the future if we take all these steps to put in the resources, to put in the process, if necessary, create a special class of judge and so on and so forth? Is that impossible by definition? And I would add that, in other jurisdictions, to the best of my knowledge, I may stand corrected, in other jurisdictions, for example, in some states in the US, it is my understanding that an arrest warrant needs to be approved by a judge under certain circumstances. And these arrest warrants are very time sensitive. And a judge has to make a decision on the balance of probabilities whether to arrest a person, and that's a serious matter, whether to arrest a person in extremely time-sensitive circumstances. Sometimes late at night, the law enforcers will go and see a judge, because that system has been created and structured and resourced in such a way that that is possible. So that's my clarification. Thank you.
A number of points here. Now, the first of which is this. You must go and find, let's take the sequence, the process of these things. First, you've got to draft something and file in court. Okay? We are now talking about the Select Committee's recommendation to do something within a matter of hours. You've got to draft and file. you've got to put aside some time for that. After that, you must find a judge. Let's say in your scenario, we have a High Court judge who does nothing but sits there 24/7, because it can break out any time, and will be available as soon as the government calls. It's technically not impossible. Of course, you can have a judge do nothing but this and no other cases. Or any time, because if he's hearing a case, he can't break the case and come and listen to you. He's got to finish the case for the sitting either until lunchtime or until the evening, depending on the scenario. Duty judges hear their cases too. So we are saying, if supposing something has happened and I want to stop the communication within the next 2 hours, do you think it's possible by going to court? Now, then there are further factors which add further levels of uncertainty. You file, you go before a judge, and you say, look, judge, it is so urgent that I'm not going to serve this on Google or Facebook or whoever, wherever it is spreading. I just need an urgent order, ex parte, and then later on I will serve. Sometimes the judge may agree, but the judge may also disagree. Supposing he disagrees, then it takes a further length of time. The decision maker, the person who has the facts, might take one view, and the responsibility for dealing with that situation also rests with the executive. I mean, you know of instances where within 24 hours there have been riots and people have been killed. Supposing the judge says, I think I would like to hear the other side, urgent as it is. It's happened, urgent inter partes, urgent ex parte applications have been heard on a contested basis. Any of these are possible. The judge could give you ex parte, but he could also ask for contested ex parte. He could ask the other side to turn up quickly. And if he does that, and the other side turns up, and then they say, we don't have time to file an affidavit, but we want to know the basic facts before we can argue. We need until this evening. We need until tomorrow morning. Once you set up a court process, then you must allow for the due process. So my point to you, Mr. Pereira, is, having now heard this explanation, is it your position that definitionally it is possible every single time, whenever we want it to be dealt with urgently, that it can be dealt with urgently in a matter of hours? Is that your position?
Mr. Pereira.
Thank the Law Minister for his explanation. And I think that there are a number of points that he made which relate to judicial capacity, for want of a better term, and process. Capacity, I think, I would imagine that based on what the Law Minister has said, he can envisage that necessary capacity can be created to deal with such a caseload based on what the Law Minister
waits for the application. That's what I said.
Yes, so I'll take it that necessary capacity can be created. We can create a special class of courts, duty judges. Capacity is a question of resource planning. So if sufficient resources are applied, the necessary capacity can be created. Next, there's the issue of process. And I think the Law Minister alluded to the fact that, well, the government will have to word a submission, even an ex parte submission to the court, and that is time consuming, and while this is going on, the clock is ticking away and the falsehood is viralizing, and so on. Well, within the ministry or the stat board or agency, the civil servants also have to word a submission to the minister or communicate with the minister. Can we not create a process whereby the communication, the form and the format of communication between the civil servant and the minister is very similar to the form and format of communication between the government and the court in those very time-sensitive cases to obtain an initial prima facie decision? So my point there is that I think at the level of process, these things, a process can be created to minimize the time lag from ministry to court. I would put it to the minister that a process can be created in that way. And I think if we address the issues of capacity and the issues of process. I mean, the minister has been talking about the current situation right now with the capacity we have and the process we have. If we can add more resources and capacity and we change the process to make it expedited to arrive at that prima facie decision to stop the parallelization, I would put it to the law minister that is perfectly conceivable. And I just want to address the other point that the minister made, that in some cases the judge will not agree. That is precisely the point. In some cases the judge will not agree if the judge feels that he's being asked to make a prima facie decision, but he's looking at it on the balance of probabilities and he feels that the executive is overreaching or the executive is abusing their power. So he may not agree in that case. And that is precisely the value of the check.
I would ask of Mr. Pereira not to put words in my mouth. When I said not agreed, it may be because he says, I want to hear what the other side has got to say. So my point to Mr. Pereira is, therefore, can I take it, and it'll be very simple, can I take it your position is that definitionally, every single time it is necessary to make a decision, you believe that the courts can be used to make a decision to break the virality within a matter of hours, every single time, when it's necessary to do so. Is that your party's position? Is that your position? If it is yes, yes. If it is no, no. That's all. It will be very good to clarify that.
Courts are sufficiently structured and resourced and the process is defined to enable that to happen, then the answer is yes.
You believe that that can be done by simply putting some submission to the court. Is that it? Whatever the civil servant submit to the minister can simply be submitted to the court.
The Honourable Minister, that a simplified process can be created to absolutely minimize the lead time between minister to court to get a decision. I mean, there is a certain amount of lead time in any case for the internal conversation between civil servants and ministers in such cases. So what we're talking about is the additional lead time between the minister and the court to get that decision to break the virality. So I would put it to the minister that a process can be defined that is very simplified to minimize that lead time. Yes.
I've got the clarification I've needed, sir. Thank you.
Thank you.
The question is that the bill be now read a second time. As many as are of that opinion say aye. Aye. To the contrary say no. Mr. Pritam Singh.
Mr. Speaker, I'd like to humbly call for a division, please.
Okay. Mr. Pritam Singh, instead of claiming a division, would you want your dissent or abstention to be recorded, or you prefer a division?
No, sir, I'd prefer a division. Thank you.
Okay. Will the honourable members in support of the division please rise at their places? Okay. Clerk, ring the division bells. It's not a question, it's a bill. The second time, I need to read the whole thing. Sergeant-at-Arms, lock the doors. The question is that the bill be now read a second time. Mr. Pritam Singh, you have asked for a division. Would you like to proceed with the division? Okay. Okay. Clerk, proceed with the division. Members are reminded that they are to be seated at their designated seats and should only start to vote when the voting buttons on the armrests start to blink. Members may now begin to vote. Members are advised to check that their names are registered according to their vote indication when the voting results are shown on the display screen. Okay, before I proceed to declare the results of the vote, are there any members who wish to claim that his vote or her vote has not been displayed or displayed incorrectly on the screen? Since there is none, I will proceed to declare the voting results now. There are 74 ayes, 9 noes, 1 abstention. The ayes have it. Sergeant-at-Arms, unlock the doors.
Protection from Online Falsehoods and Manipulation Bill.
Committee stage what day, Minister?
Now, sir, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as are of that opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 12 stand part of the bill. As many as are of that opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it. Clause 13, Ms. Andrea Ong.
Mr. Deputy Speaker, may I take this opportunity to clarify my earlier statement? The proposed amendments were vetted by the Parliament Secretariat on procedure. Mr. Deputy Speaker, may I seek your permission for the debate to range over clauses 13 and 25, as they are similar clauses.
Please proceed.
Thank you. Mr. Deputy Speaker, I have already, with the permission of Speaker, addressed these amendments during my debate at the second reading of the bill earlier today. Let me just round it up. We welcome Minister's assurances that the amendments put forth will be addressed in subsidiary legislation, because these assurances were not demonstrated in the bill when it was tabled. However, our stance is unchanged, and we maintain that this amendment to the primary legislation is necessary to ensure that any future minister and/or government would have to first change the primary legislation, that is tabling it in Parliament, and therefore a higher barrier to clear. Mr. Deputy Speaker, I beg to move the amendment standing in my name as indicated in the other paper supplement.
The question is as proposed by the member. As many as... Sorry,
No, sorry, I just...
Okay, as many as are of that opinion, say aye. Aye. To the contrary, say no. No. I think the noes have it. The noes have it.
And I'd like to register for the amendments proposed by the NMPs. The Workers' Party's position is to abstain on them. I can abstain on each one of them individually, but Chairman can take note that we will abstain on all the individual amendments. So whichever way Chair would prefer, I would proceed that way.
I think we'll take it as that you are abstaining on all of them to save time.
Thank you, Chair.
Thank you. Okay. Which one is it now? Which one is it now? 18I. Okay. Clause 13. The question is that Clause 13, the original Clause 13, is then part of the bill. As many as are of that opinion, say aye. Aye. To the contrary, say no.
No.
I think the ayes have it. The ayes have it.
Mr. Chairman?
Yes.
I wish for my dissent to be recorded, Deputy Chairman.
I do too.
Okay. Members who wish their dissent to be recorded, please stand up. Ms. Ong, you're also dissenting? Yes, okay. Okay, clerk, please record the dissent. Okay. The ayes have it. The ayes have it. The question is that clauses 14 to 16 stand part of the bill. As many as are of that opinion, say aye. Aye. To the contrary, say no. No. I think the ayes have it. The ayes have it. Clause 17, Ms. Anthea Ong.
Mr. Chairman, may I have your permission for the debate to range over clauses 17, 29, 34, 35, and 44, as they are similar clauses?
Please proceed.
Mr. Chairman, I beg to move the amendment standing in my name as indicated in the order paper supplement.
Okay.
Again, we welcome the Minister outlining the details of the subsidiary legislation that addresses these amendments in this regard yesterday. However, any future minister and/or government could still make changes in the subsidiary legislation to enact rules to unnecessarily delay the appeal process, obstructing appellants' access to swift judicial oversight. With this amendment, any future minister and/or government that attempts to delay the appeal process would have to first change the primary legislation. Again, it's a higher barrier to clear.
The question is as proposed by the member. As many as are of that opinion, say aye. To the contrary, say no. No. I think the noes have it. The noes have it. Clause 17. The question is that Clause 17 stands part of the bill. As many as are of the opinion, say aye. Aye. To the contrary, say no.
No.
I think the ayes have it. The ayes have it. Yes.
Mr. Chairman, we wish for our dissent to be recorded, please.
Okay. Members who wish to have their dissent to be recorded, please stand up. Okay. Clerk, please record the dissenting votes. The ayes have it. Clause. Which one is it now? Okay. The question is that clauses 18 to 24 stand part of the bill. As many as are of that opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it. Clause 25, Ms. Anthea Ong.
Mr. Chairman, I beg to move the amendment standing in my name as indicated in the order paper supplement.
Okay, the question is as proposed by the member. As many as are of that opinion say aye.
Aye.
To the contrary say no. No. I think the noes have it. The noes have it. Clause 25. The question is that clause 25 stand part of the bill. As many as are of that opinion say aye. Aye. To the contrary say no.
No.
I think the ayes have it. The ayes have it. Yes, please.
Mr. Chairman, we wish for our dissent to be recorded.
Okay, members who wish the dissent to be recorded, please stand up. Clerk, please record the dissent. I think the ayes have it. Okay, the question is that clauses 26 to 28 stand part of the bill. As many as are of that opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it. Clause 29, Ms. Anthea Ong.
Mr. Chairman, I beg to move the amendment standing in my name as indicated in the order paper supplement.
The question is as proposed by the member. As many as are of that opinion say aye. Aye. To the contrary say no. No. I think the noes have it. The noes have it. Clause 29. The question is that clause 29 stand part of the bill. As many as are of that opinion say aye. Aye. To the contrary say no. No. I think the ayes have it. The ayes have it. Yes.
Mr. Chairman, we wish to record our dissent, please.
Okay, members who wish to have the dissent recorded, please stand up. And clerk, please record the dissenting votes. Yep. The ayes have it. Okay. The question is that clauses 30 to 34 stand part of the bill. As many as are of that opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it. Clause 35, Ms. Anthea Ong.
Mr. Chairman, I beg to move the amendment standing in my name as indicated in the order paper supplement.
The question is as proposed by the member. As many as are of that opinion say aye.
Aye.
To the contrary say no. No. I think the noes have it. The noes have it. Clause 35. The question is that clause 35 stands part of the bill. As many as are of that opinion say aye. Aye. To the contrary say no. No. I think the ayes have it. The ayes have it. Yes. Well,
Mr. Chairman, we wish for a dissent to be recorded, please.
okay. Members who wish their dissent to be recorded, please stand up. Clerk, please record the dissenting votes. The ayes have it. The question is that clauses 36 to 43 stand part of the bill. As many as are of that opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it. Clause 44, Ms. Anthea Ong.
Mr. Chairman, I beg to move the amendment standing in my name as indicated in the order paper supplement.
The question is as proposed by the member. As many as are of that opinion say aye. Aye. To the contrary say no. No. I think the noes have it. The noes have it. Okay, clause 44. The question is that clause 44 stands part of the bill. As many as are of that opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it. Yes.
Mr. Chairman, we wish for our dissent to be recorded, please.
Okay. Members who wish the dissent to be recorded, please stand up. Clerk, please record the dissenting votes. The ayes have it. Okay, the question is that clauses 45 to 62 stand part of the bill. As many as are of that opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it. New clause A, Associate Professor Walter Teixeira.
Mr. Chairman, I beg to introduce a new clause entitled Principles of Act.
Principles of Act.
Associate Professor Walter Teixeira.
Mr. Chairman, I beg to move that the new clause be read a second time. The principles of Act, I've referred to them in my second reading debate. The purpose is to provide guidance to the proportionate and limited exercise of powers under the Act. I accept the Minister believes that these guarantees are already provided for in the existing bill, or will be provided in subsidiary legislation. Nonetheless, I think this debate has shown us that it's not easy for non-lawyers to understand or interpret the appropriate scope of the Act. So I think it's important to provide a plain language, set of principles in the primary legislation that cannot be changed by a future government without returning to Parliament.
Okay. The question is that the new clause be read a second time. As many as are of that opinion, say aye. Aye. To the contrary, say no. No. I think the noes have it. The noes have it. Yes, members who wish to record the dissent, please stand up. Okay, clerk, please record the dissent. 31A. Oh, sorry, the assent. Okay, next one. 31A. 31A. Yeah, 31A. Okay. New clause B. Ms. Anthea Ong.
I beg to introduce a new clause entitled Independent Counsel to Strengthen Society Against Online Falsehoods.
Independent Counsel to Strengthen Society Against Online Falsehoods.
Ms. Anthea Ong.
Mr. Chairman, I beg to move that the new clause be read a second time. The Council will be empowered to routinely evaluate the actions taken under this Act, make recommendations to the Government, and provide accountability to the public through annual reports on the Act. The Council will also oversee and support non-legislative action against online falsehood, including public education. Unlike councils stipulated in other legislations, we're proposing that members of the Council are to be appointed by a select committee of Parliament and not by a minister, ensuring that the Council stands as a separate and independent body from the Government. The Minister had said he agreed with the intent of the Independent Council, and I believe that councils for such a purpose do not lead to unnecessary bureaucracy, because we have numerous precedents to cite in support of this, like the National Council on Problem Gambling.
The question is that the new clause be read a second time. As many as are of that opinion, say aye.
Aye.
To the contrary, say no. No. I think the noes have it.
Mr. Speaker, Mr. Chairman, we wish for our assent to be recorded.
Okay, members who wish to have that assent to be recorded, please stand up. And clerk, please record the dissenting votes. The noes have it. Okay. The question is that the schedule stands part of the bill. As many as are of the opinion, say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. Bill to be reported. Minister.
Mr. Speaker, I beg to report that the bill has been considered in committee and agreed to without amendments.
Third reading what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as are of that opinion, say aye. Aye. To the contrary, say no. No. Mr. Pritam Singh.
Mr. Speaker, I'd like to call for a division, please.
Okay. Okay. Members who support the division, please stand. Okay, clerk, please take a division. Sergeant at Arms, lock the doors. The question is that the bill be now read a second time. Sorry, a third time. Clerk, please proceed to the division. Members are reminded that they are to be seated at their designated seats and should only start the vote when the voting buttons and the armrests start to blink. Members may now begin to vote. Members are advised to check that their names are registered according to their vote indication and when the voting results are shown on the display screen.
Deputy Speaker, sir, my name is not reflected.
Okay. Okay. Okay, please take that. Yeah. Okay, clerk, please record the vote. Okay. Sorry. Okay. May I ask what is your vote?
Yes.
Yes. Okay. Thank you. Sorry, Professor. Professor Lim San San votes yes. Yes. Now, okay, before I proceed to declare the results of the vote, are there any members, other members who wish to claim that their vote has not been displayed or displayed incorrectly on the screen? All right, okay. Professor Lim San San, can I confirm that your vote is yes? All right, okay. I will now proceed to declare the voting results. Aye 72, no 9, abstentions 3. The ayes have it. The ayes have it.
Protection from Online Falsehoods and Manipulation Bill.
Leader Dawes.
Mr. Speaker, Mr. Deputy Speaker, on behalf of the leader, I beg to move that Parliament do now adjourn to a date to be fixed.
The question is that Parliament do now adjourn to a date to be fixed. As many as are of that opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it. Order. Order.